Please, Mrs. Iverson. There. I'm sorry, Mr. Iverson. You may proceed.
This was not about your.
No, it was not.
Or maybe it was. You'll never know.
Good morning, Your Honors. Kendall Stivers Jones on behalf of the appellant, Mr. Bobby Marable. Judge McMullen, with the court's permission, I'd like to reserve 3 minutes for rebuttal.
Got you. Thank you.
This case is very straightforward in the facts of the offense and not so straightforward in the issues that it has generated. There are 5. I'm only going to speak about 2 today unless the court has any specific questions about the other ones, which I'm happy to answer. We'd also ask the court to accept, I believe the state is in agreement with Mr. Marable, that Mr. Marable should have been sentenced as a range 2 offender on his aggravated assault conviction.
Can I ask one question on that?
Absolutely, Judge Montgomery.
So, at the sentencing hearing, he agreed that he was.
He did.
range 3? Okay. So even though you agree and your lawyer agrees, we reversed on you.
Correct. I'm guessing the court's asking about a waiver. I believe this court, there's a case at this court that I cite, I believe Gordon, where it was taken up on plain error, even when they didn't object, and reversed for that. If that's a court's question.
Didn't object is different than agree.
That's correct. But
Just curious.
yes, we did address that in our brief and argue that even if it's under plain error, that Mr. Marable's entitled to relief, and that would not be unprecedented for this court to do so. But as I said, the facts of this case are pretty simple. The victim in this case, Miss Patterson, was getting out of her car on the evening of May 10th, 2016, when Mr. Marable came up to her, attacked her, choked her to the point of unconsciousness, and then took her in his vehicle to his home, where she remained until the next morning, where she left the trailer while he was asleep and got a neighbor to drive her to her place of work and then to her home. The state indicted and convicted got a conviction on Mr. Marable for aggravated kidnapping and aggravated assault. The 2 issues that we are going to discuss today are the first 2 issues in the brief. And number 1, first being that the state did not present, or the jury lacked sufficient evidence to convict Mr. Marable of aggravated kidnapping. Now, we argue in our brief there is enough proof to substantiate kidnapping. But the point that we distinguish is that the elements of aggravated kidnapping require not only a false imprisonment, but a false imprisonment in conjunction with one of 3 other modes of culpability. The one that was indicted was a false imprisonment where the victim suffers bodily injury. Now, we're not disputing that Ms. Patterson suffered injuries, but all of the injuries and the proof trial showed that the injuries were sustained as a result of the aggravated assault that occurred before any aggravated kidnapping, any false imprisonment, any removal or confinement from the scene of that aggravated assault. Now, she was unconscious at that point, but nothing substantiated.
So are you saying I can't have an aggravated kidnapping in which the defendant walks up to their victim, knocks them out in order to kidnap them? That can't be an aggravated kidnapping?
I don't think so. So the aggravated kidnapping requires, as charged
So that
here.
has to be an assault and a kidnapping. It cannot be an aggravated.
Well, the proof showed that she was unconscious. She woke up when she was in his truck. Now, if he decked her and knocked her out again during that and she was unconscious, then that would be an aggravated kidnapping where she suffered bodily injury. But when you've got 2 different offenses, as we point out, the white instruction
So
was...
incapacitating my victim so that I can kidnap them is not an aggravated kidnapping?
It's a kidnapping.
Well,
The kidnapping, the elements are clear. It has to be a bodily injury suffered as a result of the kidnapping or the false confinement, the removal or confinement unlawfully where there was substantial interference with the person's liberty. It's got to be...
after I've confined them.
Correct.
Or as
And
part-
it's not, and I may have confused a.
No,
a bit of-
I understand your argument. I just want to make sure that
Yes.
we're drawing that's the bright line you're saying we have to draw, is that,
In this case, yes. Now, I'm not saying that the proof can't always, a single act can't substantiate two different criminal offenses. We're saying here is the nature of the second charge, which was that the kidnapping was sufficiently distinguishable from the aggravated assault such that a white instruction was properly tendered. So you have that second offense, but the second offense, it's at its base a sufficiency argument. That statute requires that there be injury during or in the course of or in conjunction with the aggravated kidnapping. Otherwise, it's just a kidnapping.
Did he, once they were at the house, wasn't there testimony that he slapped her?
Yes.
Okay, she said it didn't hurt.
She did not go beyond that. She said, I think specifically that he slapped her, spit at her, and threatened her again with choking her, which would be enough. The threats would be enough to establish the element of kidnapping. But we've cited a
Say that
case.
one more time. I'm sorry, you slapped her, and what was the rest of your sentence? I missed that.
The proof that she testified to of her interactions with Mr. Marable after her removal from her home or car outside of her home, where that he slapped her, spit at her, or I can't remember spit at or spit on, I don't want to miss, but there was spitting involved. And that he threatened to choke her again. So that's enough for kidnapping. What it's not enough is it has to be the aggravated kidnapping, the false imprisonment, where they suffer bodily injury. And we cited a case that says,
Bodily injury, right.
well, there's no testimony that caused pain. Now, this court would,
On the physical pictures of her face, were there any injuries to her face?
there were scrapes on her knees and legs. There was bruising around the throat, trachea area and a raspy voice to substantiate that she was choked. Beyond that, I don't remember any injury to her face other than she had a bloodshot eye, which again would be consistent with lack of oxygen and strangulation. We're not saying that it couldn't be, but what the case law has, as this court has said previously, and the one case that I was able to find where they addressed it, is that a slap without testimony further that it fits that statutory definition of bodily injury is not enough for that to substantiate it. And so that gets us into the second issue, which is the trial court's expanded jury instruction. The state indicted Mr. Marable and proceeded at trial on the theory that aggravated kidnapping was accomplished, as I've said, where the victim suffers bodily injury. However, the jury instruction that was read at trial, which was not objected to, included two other methods by which someone may commit aggravated kidnapping. The first one was the use of a weapon, which, as the state pointed out, and we agree with, there was no testimony of that in the trial. The other one is a little stickier because it is the use or threats of violence to intimidate or cause panic. So if the court, Judge Montgomery, like you mentioned, if there's some if they don't believe that any bodily injury occurred after that, then they absolutely have proof to substantiate that other one where he's caused terror or threatened harms of violence, because there absolutely was testimony by Ms. Patterson, which the jury accredited, that he threatened to choke her or threatened to do other acts of violence to her once they reached his home. So at that point, it does not become harmless, which is the standard of review that we would be under for a non-structural constitutional error. The state has argued that there wasn't proof to substantiate that, and as I just said, there absolutely was enough to do that, so that if the trial courts expanded that jury instruction, that raises the possibility of whether or not the jury, in fact, convicted Mr. Marable for the offense that he was indicted in, which he mounted his preparations for his defense.
let me ask you, I know you said it was not objected to, we're going under plain error, but was there any discussion at all as, prior to the trial court instructing, saying, I'm going to instruct on this aggravated kidnapping this way, and here's why?
I believe the jury instructions, they went over the jury instructions, or there was some mentioned by the trial court about the jury instructions. I don't think it was objected to or.
Right, yeah, I just didn't, I mean, out of just curiosity, what made the trial court instruct the way he instructed? Did he
That I
comment?
don't,
Yeah.
that I don't know. The only thing I could give you would be anecdotes from trial practice of kind of zoning out when you're done with your trial. I will mention that I am the one with the cumulative error waiver argument. Or I guess we are. So I would like to address that now. The state has argued that cumulative error was not argued in our motion for new trial, and they are correct in that. But as we pointed out in our reply brief on, I think, page 10, whether or not that's waived is a case-by-case basis. There have been cases that I cited where this court has found that individual errors were not addressed, but there was enough to substantiate review on cumulative error and to reverse and remand. And if this court has no further questions, I'll sit.
I do have
Yes, Judge.
another question. Okay, so when he choked her out at her house,
Mm-hmm.
and apparently must have carried her out to the vehicle, right? And so what you're saying is that if you have incapacitated somebody and then you intend to move them, then it really doesn't make any difference you can't make it aggravated.
No. Now, there has to be testimony that there was bodily injury suffered as a result or with the aggravated kidnapping. The way the statute reads, I think, is what the court saying that it's unfair that somebody has incapacitated somebody.
Yeah, she was incapacitated and suffered bodily injury as a result of that incapacitation because it choked her out, and we have said there were marks on her neck, and obviously carried her out to the car as part of the kidnapping. But you're saying that because she was passed out and had been choked out and injured before he physically moved her to the car, that in turn means it's not aggravated?
I think it means that in the absence of her testimony, while it's unfair that she was unconscious and not able to know what was going on, I don't think that in the absence of her testimony is enough to have a circumstantial inference that some of those injuries occurred enough to get to beyond a reasonable doubt for false imprisonment where bodily injury occurred. She testified, all the injuries that she testified to, with the exception of the slap, which she did not give any further testimony, were accomplished during the aggravated assault. We're not saying this is not a kidnapping, but it's not an aggravated kidnapping. Thank you, Judge Montgomery. And I'll rest on the remainder of my time.
Good morning, Your Honors, and may it please the court. Ronald Coleman on behalf of the state. This court should affirm the convictions of aggravated assault and aggravated kidnapping, but the state does acknowledge that the defendant's conviction for aggravated assault, his sentence, should be reduced from the maximum within range of range 3 of 15 years down to the maximum within range 2 sentence of 10 years. And Judge Montgomery, you pointed out, the defendant agreed to this, and I want to sort of distinguish, this isn't necessarily a plea deal or an agreed upon sentence where the defendant agrees to plead out of range.
Okay, let me stop you just real quick. Okay. Were the judgments of conviction introduced? They get the sentencing here?
Yes, I believe they were.
And so did they, did the judge was there any discussion at all about what this conviction from the other state was and whether or not it had a comparable charge in Tennessee?
No, Your Honor, and that was because I think both parties and the judge sort of mistakenly thought that this was a child abuse, just straight one-for-one conviction. And so what defense counsel, the judge says the state's submitting that the defendant is range 3 for this. Defendant, what do you think? And defense counsel said, well, I'm looking at it and I think that's right. But it's waived, but the state agrees that this rises to the level of plain error. The facts, simply put, are that this.
So what proof do we have that it's not, let's say, a felony?
We have the conviction, and so we can compare the elements.
So we're supposed to rely upon, you're looking at the other statute in the other state to compare it to Tennessee, which the trial judge didn't do in this case.
That's correct, Your Honor. The trial judge didn't, but when you look at it, the elements simply aren't there. The age difference. It was a felony, but in Georgia, the offense that he committed in Georgia had an age requirement where the child had to be under 18, which was equivalent to the child abuse statute in Tennessee, except that if they were only under 18, it was a misdemeanor, and they had to have additional proof that the child was under 6 at the time for it to rise to the level of a felony. And we don't have that proof, and there's also potentially. We have the elements, and that's the thing when we're looking at whether the defendant's range, we don't look at the factual basis underlying the conviction. We look at the elements of the offense as convicted. And so looking at that, the defendant, that offense, when it was committed, was not a felony in Tennessee at that time. So the state agrees that he should be a range 2 offender, but all this court needs to do is reduce it from the maximum range 3 sentence of 15 to the maximum range 2 sentence of 10. Unless this court has further questions of that, I will address the first issue of sufficiency here. The defendant argues, and I think that the injury must be sustained after confinement, and that's simply not what the statute says. I think Judge Dyer, as you mentioned, if this is at the initiation of the kidnapping, at the inception, if the defendant inflicts the bodily injury in order to kidnap someone, that qualifies as bodily injury inflicted during a
But
kidnapping.
they're not saying that that's not necessarily true. The way I understand their argument, there was no proof to support that.
The proof at trial was the defendant strangled this victim to the point of
Before
unconsciousness.
removal or confinement?
In order to remove. And that's all the statute requires. You don't have to do it after the confinement has started. You can do it as the initiation of that confinement. The only way he started to confine this victim by choking her and incapacitating her. And he did that so that he could continue to confine her and to engage in false imprisonment. And that is all that the statute requires. The defendant attempts to rely on White and mention that there was a White instruction here and that this initial strangling, the bodily injury inflicted during the kidnapping, that was in conjunction, or that was at the same time as the aggravated assault. And that's irrelevant here. White focuses on the temporal nature of the kidnapping and says it must be more than that necessary to commit the underlying aggravated assault. It doesn't say that you have to inflict a separate injury than the aggravated assault. It focuses on the temporal nature, and White was aware these individuals stole, I believe, car keys and then intended to rob the victim from their ATM and essentially kidnapped the victim to drive them there. And what White said was that was all part of the underlying offense, that wasn't a separate kidnapping. It's not what we have here. The White instruction was given, and as far as it relates to the aggravated kidnapping versus the aggravated
I thought the
assault.
White instruction was given only in regard to the aggravated assault. That's part of their argument and not, I'm trying to remember which.
Are you saying White doesn't apply?
No, I say White doesn't apply to their argument of the infliction of injury.
Okay.
White certainly applies to the underlying aggravated assault. And if the defendant removing this victim to his house and keeping her there for several hours was all part of the underlying aggravated assault, then we would have an issue between the kidnapping and the assault. But when we're looking at the sufficiency of the evidence for kidnapping, and specifically whether bodily injury was inflicted during that offense, we don't need this temporal question mark that White brings up. All we look at is, was bodily injury, was the defendant, was the victim kidnapped where the victim suffered bodily injury? And here, the defendant initiated the kidnapping by inflicting that bodily injury. That is all that the statute requires.
So using probably the wrong terminology, but you'll understand. So the injury, the defendant seems to be arguing that the injury has to take place after the taking, after the confinement.
That's my
And-
understanding.
And your argument is, no, if the injury, and in this case, the choking out to unconsciousness, is what allows for the taking, the confinement to take place, then that's an aggravated kidnapping.
Yes, Your Honor. If that is the inception of the, now, if the defendant here had strangled the victim and knocked her unconscious and gone and picked up a hamburger or something and come back and said, oh, she's still gone, I need to take her somewhere, then no. But whenever he strangles her and throws her into his truck, then that is part of.
There's not a break, you're saying as long as there's not a break between the assault and the kidnapping, then they're all one kidnap. It's all part of an aggravated kidnapping as opposed to an assault, hamburger, come back and kidnap.
I think that's exactly right. If you incapacitate a victim, or even if you just inflict bodily injury on a victim as you are trying to take them away, as you start the taking, that qualifies. That meets the elements of the statute. And unless this.
Most people, when they have hands around their neck of somebody that's stronger than they are, probably is not free to move about. You know, if they've already been seized.
And I again, that is the initiation of the false imprisonment. So I would agree with Your Honor there. If there are no further questions on
Yeah,
that.
what about the jury instructions?
So the jury instruction, and the defendant mentioned that this error wasn't harmless, and I will just reiterate, we are here on plain error review, and this doesn't rise to the level of plain error because consideration isn't necessary to do substantial justice. And that's when we're looking at what happened at trial, what the proof at trial was, and even the state's arguments, I think, are reflective of why this isn't necessary. Consideration is not necessary to do substantial justice. So at the very beginning of trial, and this is on volume 2, page 107, the state discussed the elements of aggravated kidnapping and submitted that the victim here, quote, suffered bodily injury because she was strangled to a point she was unconscious. And then again, in closing, it told the jury, aggravated kidnapping is false imprisonment as defined. You'll get that definition where the victim suffers bodily injury. It then argued the victim was strangled. She testified she was passed out, and then she was moved from Milan to Humboldt. That's aggravated kidnapping. So the state, at least twice, reiterated to the jury, what you need to find to establish aggravated kidnapping is that this infliction of bodily injury, and the infliction of bodily injury we were relying on is this strangulation. And so the defendant here concedes that there was no weapon. So one of the extraneous instructions certainly had no effect. And then secondly, when the state is heavily emphasizing the strangulation and the victim is emphasizing the strangulation, the intimidation or causing panic simply doesn't rise to the level of plain error, where it more probably than not affected the outcome. Because again, the state and the victim were all focused on this strangulation. And so the state would submit that this does not rise to the level of plain error. And Judge Dyer, I know you asked, were there discussions about the instructions? What I remember is the judge, prior to closing, kind of says, here are the instructions, let me know if you have any issues with them. And nobody really says anything. And like my colleague, I think it can kind of be attributed to just sort of the court zoning out for a second. But ultimately, this does not rise to the level of plain error. And then with this, again, this is the case where the state has argued cumulative error waiver. There is a long line of cases that argue that stand for the proposition that the failure to include this in your motion for new trial.
So you're saying we can't consider multiple errors in combination?
I think this court can. It is a better policy for the defendant to raise it in the motion for new trial, and I think it's especially better, and I haven't fully researched the cases that the defendant relies on, but I think there's a difference if all of the errors are up on plenary review and they were presented to the trial court and the court considered it, and they didn't say like, oh, and also cumulative error, then it might be more apt for this court. But even if this court finds that there's not a waiver, the errors here, such that they were, certainly don't accumulate because they're separate errors. And so we would submit that, again, we would ask this court to find that it had been waived. Even if it's not been waived, the defendant hasn't established that the cumulative effect of these errors warrants reversal. Unless there are further questions, we ask this court to, again, affirm the convictions and simply change the one sentence from 15 years to 10. Thank you.
Thank you. Ms. Stivers-Jones, you have your rebuttal.
Judge Montgomery, to your point about the foreign convictions test, the trial court did not perform any kind of analysis, and to its credit, that nobody disagreed with it when it did so. But I think both the state and Mr. Marable have included the statutes that Mr. Marable was convicted under at the time in Georgia, as well as the statute in effect in Tennessee. And I think the difference was sort of a state versus Mateko, where Georgia punished for the risk of harm, whereas we required an actual harm. Like something like, I think Mateko was like, the kids had fleas or something, which is gross, but it's not an actual harm.
Let me ask you on this real quick.
Yes.
Do you agree that it really is us just saying it should be range 2 and sending it back for the maximum within range 2 versus the maximum within range 3? I mean, the trial court put him at the maximum range 3. Is there any point in actually asking him to re-sentence on that, or do we just send it back with the direction to enter new judgments?
Well, I would argue it should be sent back for more resentencing. But I think there's proof in the record to substantiate these to run consecutive, because I think there was enough to substantiate that he had an extensive criminal history. When something like this occurs, I think it's always best practice just to let the trial court resentence. Even I know this court can do that when there is enough, it feels like there's enough in the record to make a decision. And the other thing I'll point out, I have only mentioned State versus White for the premise that these are two separate offenses. And by the nature of these offenses, aggravated kidnapping requires, I'm not saying that there can't be a situation in which a factual scenario can't be used for both to establish both offenses, but here, aggravated kidnapping requires, not White or anything else, that statute requires that the injury occurs, or where bodily injury occurs as a result of the false imprisonment. There was no testimony by the victim, Ms. Patterson, that any kind of bodily injury occurred after that, other than.
I know he's, or at least appeared to say it somewhat in jest, but what about Judge Montgomery's point that you're confined if someone's got their hands around your throat and you can't get out of that, are you not?
So you're saying that both of these are, there shouldn't have been a White instruction, that this is all part of one aggravated kidnapping, and the aggravated assault should fold into that?
I mean, when he said it, he kind of chuckled, and then I sat here and I thought about it, and, you know, and I don't know what the proof is, but assuming it's like how I'm picturing it, he's on top of her, and he's got his hands around her, she's pretty confined at that point, is she not?
Well, that could be, but then you're getting into, if there's any choking, aggravated assault is gonna be also a false.
Well, I guess my
imprisonment.
point, though, and I don't know if this is exactly what Judge Montgomery meant, but at that point, it is becoming part of the kidnapping. It's not like it's an assault and then a kidnapping. It is the assault that is allowing them to kidnap her, because they've started confining her at that point, they being the defendant.
Well, that's getting into whether or not the White instruction was appropriate at all, I think. If it's not sufficiently attenuated. If that's how I'm reading what the court is arguing.
The
Or,
court is
or
thinking.
postulating.
The court is thinking. The court is not arguing.
Postulating. What the court
All right, you're at a red dot unless Judge
No,
Dyer has
I'm done, I'm
additional
sorry.
postulation.
I do not. And for the reasons argued in our brief, we would ask this court to accept the state's generous acknowledgement on the range and reverse for the issues listed in our brief. Thank you.
Thank you. We'll take the case under advisement, and I think we're going to take about a 10-minute recess.
All rise.